Hello everyone. Tonight we will talk about the famous ByLock app and the reports recently coming about the ByLock apps. My guest is a seasoned exiled journalist, Kerim Balci again. Normally we meet regularly with him every week to discuss issues, but this special program will be only about the ByLock reports and the two recent reports that came about this ByLock app. For the ones who doesn't know what we're talking about, ByLock is we can say the backbone of the Turkish government's claim or Turkish regime's claim about the Gülen movement and their culpability in the coup attempt. On that basis, they have arrested and they have sacked 150,000 people, which 75,000 of them almost are in prison, and the rest of them are still going under trial. Thousands of passports have been cancelled. The government claims that this is how they define one of the main items in their checklist, how they define whether someone is a Gülenist, hence a terrorist. So it's an app which was on the market, but we'll talk about in details with the Kerim Balci, and I'll ask viewers to do their own research because we'll be talking on specifics of the report. Welcome, Mr. Kerim Balci.
Hi.
Hi. I think there is two different reports with two different reasons, but let's start with the ones that came about in UK. Who authored the report, and what is the motive? What is the reason behind preparing this report?
The report that came from William Clegg office was prepared by three people. First of all, William Clegg is a well-established lawyer in Turkey who worked in the Central Criminal Court in London for about 23 years. He's an expert on English criminal law and European human rights law. This report was supported by an expert on IT issues, Simon Baker, again a lawyer from United Kingdom, and an expert on IT issues, Thomas Moore, who is an established expert witness institute member. By and large, this is a report prepared for any kind of future case that the detentions and arrests in Turkey will come to the European Human Rights Court. The report was prepared, the European Human Rights Convention in the back end of their minds. So the main question that William Clegg and his friends are asking, whether detention of people in Turkey on basis of downloading or using a ByLock app is permissible within the European Human Rights Convention. Is there any human rights breach or breach of any article of the European Human Rights Convention in these detentions and arrests? This is basically the question that is asked and answered.
What do they look at to prepare these questions and answers? What is their material? Do they look into the IT specifics of the ByLock app or anything else? What is their material?
William Clegg's report is a report over a report, actually. It is based on Thomas Moore's own report prepared basically on the report prepared by Turkish National Intelligence Agency. We will use the term MIT here, but our spectators shouldn't mix it with the rather credible Massachusetts Institute of Technology. This is not that one. This is the Milli İstihbarat Teşkilatı in Turkish, National Intelligence Organization of Turkey. So MIT has prepared a report on ByLock and its use, claiming that ByLock was an application encrypted message and communication used exclusively, and this is very important, exclusively by the members of what they call Fethullahist Terrorist Organization, or FETÖ, the Gülen movement. The Thomas Moore's report is actually largely criticizing this result and suggesting that, in fact, the report of the MIT cannot be used as an evidence in the Turkish courthouses, and in fact, it has all kinds of internal inconsistencies. It itself does not reach to the conclusion that anybody who downloaded or used ByLock is doomed to be labeled as a member of a terrorist organization.
Shall we start then, like talking about what is specifics of Thomas Moore's understanding of the app and the way it has been reported by the Turkish National Intelligence Unit? Because I think it is far easy to understand, rather than the legal aspect of the issue. As an expert, what did he found interesting about the app and the National Intelligence Unit's report on the app, and the way they are using it as a definitive checklist of whether someone is a Gulenist or not?
First of all, Thomas Moore underlines one major fact. The author of the MIT report is unknown to the court, to the writers of this report also. It's unknown to the public. In fact, the methodology used by the MIT experts while preparing the MIT report is also unknown. It is not made public. So the first criticism that comes from Thomas Moore is this: you cannot present a report by an intelligence agency to a courthouse as an evidence without giving the name of the experts that prepared the report, because the accused people should have the right to actually counter the arguments of the authors. We don't know who wrote this. We don't know whether they were really experts on this issue. We don't know whether they are accountable of what they have written or not. For example, Thomas Moore adds a text to a declaration to his own report and says, I am this person, I am here, this is my contact information. If any courthouse invites me and asks me questions about my observation, I am accountable about my observations, and I'm ready to come and actually answer any kind of question. This should be, he says, the style a witness report should be prepared. An expert witness should be prepared. And MIT report, by and large, doesn't fit into the overall description of what is an expert witness that is presented to a courthouse. So methodologically, he says, any courthouse anywhere in the world cannot use this MIT report as an evidence. The second issue is internal inconsistencies, and Thomas Moore deals with two basic inconsistencies in the MIT report. One is, it's a technical issue, but the MIT report on the one hand claims that by way of using a firewall and blocking people from Turkey who didn't use a VPN server, the programmer wanted to prevent anybody from Turkey to use the app, forced them to use VPN. Well, using VPN does mean that actually the IP addresses of the users are not known to the server in Lithuania. They are not known to the administrator of the ByLock program, and they cannot be known to the Turkish intelligence agency unless they have taken the same information from the VPN servers. And the VPN servers are universal servers, mainly in Western countries. The MIT report mentions nothing about the VPN servers.
If the ByLock users and mainly Gulenist ByLock users are asked, according to the report, to use VPN to block their IPs, then by this definition, National Intelligence Unit can't claim that the identified IP users are Gulenists. That's identified IP users are not Gulenists because they didn't use VPN, or the report is saying either of its claims wrong.
Perfect.
Yeah.
This is exactly what Thomas Moore says. It says either you have detected wrong IP addresses, or you shouldn't be able to detect any IP address because those IP addresses are unknown to the servers in Lithuania, even if MIT has actually managed to infiltrate into the building of the servers in Lithuania and took the control of the disks that had 109 gigabytes of information. There you won't find the IP addresses because the administrator forced people to use VPN. On the other hand, the MIT report itself says that we have managed to decipher the IP addresses of 165,000 users in Turkey. Thomas More says this is impossible. You are either doing wrong IP detection, or you are altogether misleading the courthouse. Maybe you have a list of 165,000 people you prepared, and you claim they used ByLock, but actually digitally saying you cannot reach to that conclusion from there. Of course, this observation of Thomas More is going to reach to Clegg's report, and Clegg is going to say, okay, this means that the MIT has arbitrarily defined who is a ByLock user. And this, in the end, reaches to the conclusion that the detentions and arrests in Turkey on basis of ByLock usage is arbitrary detention.
So they are effectively a cover-up evidence in here. Like they already decided who is Gulenist in their minds, and they're saying these people also used. So that explains the famous fact that someone who was using an old Nokia phone has been arrested on the basis of using ByLock. So it wasn't actually, in a way, so strange, because they just assigned an IP number and they wanted to arrest him, and they said he used ByLock, although it was impossible. So what else? What else the report says?
Thomas More deals with a second contradiction that the MIT report has about SSL certificate. The MIT report states that the fact that the coder of the ByLock program used self-signed SSL certificate instead of downloading an internationally renowned company's SSL certificate was in order to control the flux of information, and so that those SSL certificate given companies will not be able to reach to the information. Thomas More says this is at the best a stupid assertion, because in fact SSL certifiers cannot reach the information. The information does not go to them. There is only one reason why you use a self-signed certificate. It is cheaper. SSL certificates cost a lot of money, so there is only one explanation. Other than that, it doesn't actually make the program more secure. It doesn't keep it to you only. So in this sense, Thomas More says either the people who prepared the MIT report were not really experts of IT issues, or they were just trying to mislead the courthouse, and he says probably the second. This is important. A third issue that Thomas More deals with is the claim by the MIT report that the fact that the servers of ByLock were in the country Lithuania was also trying to make it more secretive. Whereas Thomas More says, well, the best place to station a secretive server would be United States or a Scandinavian country. The only reason that somebody hires a server in Lithuania is because it is cheaper. And in fact, Thomas More claims that the fact that the server was only in one single country made it more, he says, weaker by means of secrecy and security. And he criticizes the ByLock coder for using only one country as the server. And in fact, this is precisely what happened, he says. If MIT, as it claimed, managed to infiltrate into the building in Lithuania, it is only because there was only one server. Instead of using one server, the code writer could have used several countries, several servers, so that when infiltrated in one of them, the agency wouldn't be able to reach the totality of the information. So in that sense, Thomas More says this is not an amazingly, military standard, secretive, encrypted communication program. This is, by and large, a simple encrypted communication program that you can find out there.
So Thomas More says, in my understanding, if the maker of the ByLock wanted it more secretive and more secure, he wouldn't have put all the eggs into the same basket. There is an exact opposite of it. If we were to take the National Intelligence Unit's report, it was made easy for if they ever hacked or infiltrated to those servers.
Precisely. And he continues actually to challenge also the claim by the MIT that the programmer of the ByLock has intentionally limited and tightly controlled the use of ByLock to ensure that the access was limited only to the members of the Gülenist organization. Well, MIT, by means of claiming that use of ByLock was exclusive to the members of the Gülen movement, was actually trying to assert that anybody who downloaded and used ByLock was a Gülenist. Thomas More says, well, this is not acceptable given the fact that this application was available to download publicly to people in Google Play Store, Apple Store, and even after then in other APK websites where you can download free of charge and so on. So it was publicly available. It was downloaded in 60 different countries. In all those 60 countries, it was one of the top 1,000 apps used. In 41 countries, it was one of the top 500 apps used. In 13 countries, it was one of the top 100 apps used. And overall, all along its existence, about 600,000 people downloaded ByLock. This actually makes the claim that these were all Gülenists or members of a terrorist organization a ridiculous claim, he says.
In comparison to where National Intelligence Agency claims that it's 165,000 of Gülenists that they have. So that makes less than a quarter of the entire ByLock users if the claims were to be true. So can we talk a little about the rest of the report? What is the findings of the report at this point? Apart from what Thomas More found, what does William Clegg and his Simon Baker, as from a judicial point of view?
As I said, the reason of writing this report is mainly about breach of European Human Rights Convention articles. So they precisely do that. They use Thomas More's report on the one hand, and on the other hand, Clegg was given the English transcription of translation of a court decision of an alleged member of the Gülenist organization from Turkey who was arrested on purely three claims, three evidences. And the claims were download and use of ByLock application, having a bank account in Bankasya, and having stayed in the past in one of the student dorms run by Gülenists.
So this is from a real case, Mr.
Yes,
X, which the information of its identity is being with the Simon Clegg, has been charged of being a member of Gülenist by his association with three lawful things which weren't illegal and probably not illegal even yet, is having downloaded an app like any app, and having a bank account in one of the regulated banks of Turkey, and also staying one of the government-regulated dormitory, privately owned dormitory. Is that right?
Yes, precisely. William Clegg says, first of all, use of ByLock cannot be used as an evidence against anybody to claim that they are members of a terrorist organization or any organization. And he bases his decision on Thomas More's report. On the other hand, He says that the Turkish courts are actually using the MIT report without mentioning the MIT report. They are copying and pasting. The prosecutors are copying, pasting certain sections from the MIT report, but they are not saying this came to us from the MIT report. And this altogether sophisticates the situation. But this is a clear evidence, he says, that the courthouses are either using the MIT report as it is, or they are using other reports that actually copied and pasted sections from the MIT report. And the MIT report, as Thomas More also underlined, cannot be used in a courthouse because of anonymity of its author, he says. On the other hand, he continues on several other issues. He, in the end, reaches to observation that already the arrest of Mr. X, actually he doesn't say Mr. or Mrs., we don't know, X, contradicts or breaches 3 articles of European Human Rights Convention. These are Article 5, Article 6, and Article 7. I will go through each one of them. But before then, he underlines the issue of derogation of Turkey's signature under the European Human Rights Convention. You will remember that soon after the attempted coup of 15th of July 2016, Turkey wrote a letter to European Human Rights Court and said that I am going to derogate my signature. Derogation of signature is this. It says I am passing through a state of emergency, so I'm going to use maximum authorities by means of limiting or restricting human rights in my country because of the security situation. Clegg underlines that derogation does not mean altogether cancellation. The European Human Rights Convention still continues on governing the process under a derogated signatory country also. So Turkey is still bound by European Human Rights Convention, and Turkey can be sued in European Human Rights Court despite the fact that it has a derogated signature. Derogation does not mean altogether being outside Human Rights Convention, William Clegg underlines. And he continues on and says that the fact that in the case of X, ByLock use and staying in a dorm house and having a bank account in a perfectly legal bank in Turkey is used as evidence without any further evidence to claim membership of an organization or a terrorist organization suggests that in fact the same mistake is being made in other cases also, and it may be a huge legal scandal. He says that about 75,000 people who are detained and who are in process of being arrested or sued on such claims is problematic, he says, and he then passes to examination of the 3 articles that I mentioned.
So what does the William Clegg thinks that Turkey or Turkish regime is now breaching human rights, European Convention of Human Rights? Which article specifically he highlights?
Particularly with Article 5, Article 6, and Article 7. Article 5 is about arbitrary detention. It is actually a Universal Human Rights Declaration article. It says everybody has the right to freedom, and nobody can be detained or arrested without legal basis. And Clegg, again, refers to Thomas Moore's report, refers to the case of X, and suggests that since the use of IP addresses to determine who actually used ByLock is unacceptable as a strategy to determine the identity of the person, this means that whoever is being detained on claim of use of ByLock is actually arbitrarily detained in Turkey. There is arbitrary detention here. And he continues on adding having a bank account in Bankasya at a time which it was not even claimed by the government that it was illegal. It was actually under regulations of the government authorities, supported by the government authorities at that time. And many pro-government people had bank accounts in Bankasya. Clegg mentions even some state companies, state-owned companies had their accounts in Bankasya.
Including Turkish Airlines, yes.
At such a time, having a bank account in Bankasya cannot be used as an evidence, he says, or staying in a student accommodation facility. And he actually puts Donald Trump into the report and says, Donald Trump does have a lot of hotels in all over the world. Can we claim that anybody who stayed in one of his hotels are actually supporting Donald Trump's philosophy? We cannot. Precisely in the same way, anybody who stayed in a Gülenist or Gülen sympathizers accommodation does not necessarily become a member of the Gülenist organization, he says. He continues on and mentions reading a particular newspaper also cannot be used as identifying membership to an organization. So using any one of these or all of them altogether is, according to him, is arbitrary detention, and it is a clear breach of Article 5 of the European Human Rights Convention.
But you also said Article 6 was breached as well. So what is that about?
Article 6 is about fair trial. Article 6 says that the court has to be independent, shouldn't take orders from other authorities, and all evidences has to be transparent, and the accused has to be able to defend himself or herself, has to be able to reach to the information about what and with what kind of information they are being sued, and so on. And it says that Clegg deals with this issue in several paragraphs of his report. It says that particularly the case X, he says, that I have in my hand as an evidence, is obviously not a fair trial because of use of MIT report. It makes already a false report being used as an evidence in the courthouse. It actually underlines it actually makes the assertion of fair trial problematic. And it says the accused person has to have the right to examine or have others examine the witnesses against him. When you don't know who was the author of a report that is used against you, how can you examine the report? How can you ask questions about it? When the report does not underline how the information was actually taken from Lithuanian server, whether it was modified or not. And he underlines Thomas Moore's findings that there were certain modifications in the information when it was brought to MIT to be examined. So under such conditions, you cannot examine it. It is certainly a breach of fair trial principle, he says, but also he underlines. Fair trial can be by means of methodology, or it can be by means of the overall legality of the court cases. And in this case, he suggests that in fact, it seems that the overall Gülenist cases, 75,000 of them, or whatever the number, seems to be unfair altogether. So when it comes to the European Human Rights Court, the court may find it necessary to deal with the totality of the cases, he says, because it seems that it's not just one use of evidence, it is altogether, the case itself is altogether unfair. So there is no judicial independence. He quotes from United States State Department's report on human rights issues. He refers to Human Rights Watch and Amnesty's reports about how many thousands of lawyers and judges being sacked from their positions, or advocates defending the Gülenist or alleged Gülenist being also arrested and so on. These are all underlining a problem by means of fairness of Turkish judicial systems, he says, and this is certainly a breach of Article 6.
So that brings us to, you also mentioned that there is a breach of Article 3.
And in fact, before Article 3, there is Article 7. Article 7 is about the retrospective legislation. You already have mentioned this without giving the article's name. And Clegg is right in saying that in the case of X downloaded ByLock before May 2016. This is the month when the Turkish National Security Council declared Gülen movement an illegal terrorist organization. And Clegg doesn't enter into that questioning that declaration, but only underlines that this is a political decision. This is not a courthouse decision. Despite that, he says, before any kind of membership to Gülen movement was perfectly legal before May 2016. Only after then you can question people why you continued on supporting this movement and so on.
Or if you want to make your case, this is the time, May 2016 is when it is defined as illegal. So after this, any relationship can be maybe used or discussed that it can be used as a membership of it, but it can't be traced back as retrospectively.
Yes, exactly. And Clegg says that what is happening here, X is actually detained and arrested for alleged crimes that were defined to be crimes after they were perpetrated. So you do something when it is perfectly legal. Later on, the authority comes and says, well, this is illegal, but then comes to you and says you are under arrest because of a thing that was not a crime when you did it. And this is unacceptable, he says. This is a clear breach of Article 7 that deals with unacceptability of retrospective legislation. Other than these, he also deals with two more articles, and he doesn't give evidence on these issues because he says, unfortunately, the evidence is not yet well collected. There are just speculations about these issues. One is Article 3, which relates to torture, and the other one is Article 9, is about the failure to permit in the courthouses the discussion about the aims and the objectives of the Gülen movement. Meaning, if the courthouse itself doesn't discuss the claim that Gülen movement is a terrorist organization, and if the courthouse directly accepts this as an axiomatic or established fact because it was a political decision taken in the National Security Council, then this is a breach of Article 9, says Clegg. In both cases, Clegg suggests that European Human Rights Convention is breached, but in Article 3 case, meaning torture case, he says, unfortunately, we have only speculations, or we have only news, credible news coming to Amnesty International or Human Rights Watch about people being tortured through, sleep deprivation, or in some cases even rape or sexual misconduct and so on. But he says, unfortunately, these reports lack the names of the people who do torture people, or whether they are taking orders from their superior authorities and so on. If one day, he says, we have names of the people who perpetrate the torture and who ordered torturing, then the issue becomes a universal human rights issue, and there is no need to go to European Human Rights Court. Then any free countries' courts, including United Kingdom's courts, can open cases against these people, because then it will become a crime against humanity, not only in the jurisdiction of European Human Rights Court, he says.
Like Mr. X or someone else have been tortured in Turkey and somehow get out and knows who have tortured him or on whose order he was tortured, he'll be actually open a lawsuit against him in any other country because that is a universal human rights breach. Okay, so I want to move on to second, like the FOXIT report. So what was the purpose of this report? Like is this commissioned by a Gülenist or advocacy organization to discuss ByLock in a different aspect, or what was the reason?
First of all, FOXIT report is a completely different thing. Yes, it deals with the same issues, ByLock, downloading and using ByLock, but it was prepared on request of a lawyer in Turkey who is actually representing an accused person of being member of the alleged Gülenist organization. And the advocate has written to FOXIT and said that the courthouse uses this MIT report against my client. I'm not an IT expert, but as far as I can read it, I can see that it is full of inconsistencies. So I am asking for an expert witness. In English, this is all Latin. I can say this is called amicus report. Amicus means friend. So amicus reports are the reports, friendly reports prepared by third parties, which is not the accused part or the prosecutor. They simply prepare reports, expert witnesses, to help the courthouse. So this report is prepared to help to a Turkish courthouse. It doesn't relate to the European Human Rights Convention. It relates directly to the Turkish law and universal legal standards. And it deals only with the MIT report. It doesn't have a particular case like Clegg had the X case, but it compared to the Moore's case report, this is stronger in the sense that they didn't only read the MIT report and made a report on it, they also reverse engineered the ByLock application, and they did their own report of ByLock application, which largely contradicts the MIT report. And in fact, it is the national intelligence report. Unfortunately, in both the reports, the authors of the report prefer to use the term MIT report for the ByLock report prepared by the Turkish National Agency.
So, because this was a bit more technical and a bit more about IT technicians who reverse engineers the ByLock and try to verify whether MIT report has any or national intelligence report has any credibility whatsoever, and also create their own ByLock report. I want to specifically ask, what are the findings of this report? For instance, one of the claim is, I think that I want to start with that, Mehmet Şimşek, one of the government ministers, he claimed in a couple of interviews that this was a military-grade encryption application. So, for instance, what does their report on ByLock says about this issue? Let's start with that.
Actually, Mr. Sezgin, Fox report studied the MIT report very well and took out 9 assertions from the MIT report. They said, overall, the MIT claims 9 points. And one of the 9 points you mentioned was there, okay? The secrecy claim. The MIT reports, or the minister you mentioned already, claims that ByLock was a highly encrypted, military level application, and it suggests that it is used only in a kind of self-structure organization for secrecy. In order to test it, FOXIT said, okay, let us compare ByLock with the similar encrypted communication programs like Telegram or WhatsApp or Snapchat and so on. And they come to the point that actually ByLock seems to be one of the weakest among these encrypted programs.
Just to clarify, are you trying to say that experts think that ByLock is much weaker than WhatsApp?
Well, in fact, experts think that WhatsApp is the strongest one.
Okay, okay.
Yeah.
So now we are facing with a very, very terrible organization who leaves WhatsApp aside to organize itself in a much less secure environment.
Apparently, they didn't need that level of security. It was just privacy. The FOXIT report makes a distinction between search for privacy or lust for privacy and desire for secrecy. Okay, and it says ByLock is apparently prepared for privacy, and it is actually quite fitting to the trends of the modern era. Everybody wants privacy because the internet is actually breaking the walls. You have no privacy in the internet communication. So the market has tons of alternatives providing you privacy. It is not secrecy that these people are after. And actually, FOXIT claims that ByLock was written and prepared for privacy of communication, not for secrecy of communication. It actually provided privacy, but not secrecy, it says.
Okay, let's go on other, specific points about what the FOXIT report has found about the ByLock and the intelligence report on it.
FOXIT report shares some of the observations of Moore's report in the sense that there are inconsistencies within the report itself. But since this is a much, technically speaking, this has an alternative study of its own, it has rather more criticism. One other point, by means of criticism of MIT report, FOXIT says that MIT found 9 IP addresses throughout its history used by ByLock, whereas FOXIT found 10. And FOXIT says that this is just a simple Google search to find the IP addresses used by David Keynes on his. This is the name of the American citizen on whom the ByLock was registered. So there were 10 IP addresses used by David Keynes in order to, host ByLock program, ByLock app, whereas one is omitted by MIT. And FOXIT asks this question: why?
It depends where the IP is, of course.
Well, yes, the last IP is in the United States, and FOXIT says that the fact that not the totality of evidence is actually considered by MIT makes the MIT report altogether flawed.
So that there was when I skimmed the report, I see a part where it also talks. There is a further alteration of the content of the conversations as well. But was it in FOXIT? I'm not sure.
Yes, it is in FOXIT. Moore also touches to this issue. FOXIT actually puts in front of us pictures from the MIT report. MIT actually put some printed screen prints into the report. And in one of those, you can see that it says, this report has 8 rows. When you count, there are 7 rows. And in fact, between the 3rd and 4th rows, the distance between the 2 rows is not fitting to the distance that the computer uses, So actually, it is clear that it's a Photoshop modification. One row is clearly erased from the print screen. And FOXIT, of course, cannot know what was written there, but it says the fact that the experts played with the content of the evidence suggests that they may have done the same in several other places. In the absence of credible report about how they received 109 gigabytes of information, how did they open it, how did they reach to conclusions, we can always say, actually, this was a flawed report. They had already their intention in the beginning to reach to the conclusion that ByLock was used only and only by Gülen movement members, and this is unacceptable. As a second point, it says. As a third point, it says that there's a real issue of transparency, and the transparency does not relate only to the fact that the author is not known. It also relates to the fact that we don't know how the disks in the Lithuanian server reached to MIT. In fact, MIT report, MIT report, suggests that we are not disclosing how we received this information in order to prevent counter-intelligence strategies and so on. But FOXIT says, okay, this is your intelligence side. This is precisely the reason why universal courts do not accept intelligence agencies' reports, because you don't give them the information. How did you get this information? Okay, if the source of information is not provided to the accused person and to the court, it is unacceptable as an evidence. And although that 109 gigabyte of information, we don't know how it reached to MIT. We don't know how during the delivery of the information, whether it was modified, it lost some of its content, whether anything else was added onto it. We don't know it because the report says there is no written report of the methodology. The MIT experts do not even care about presenting the court about credibility of their methodology. FOXIT report continues on this issue and suggests one further point as a fourth criticism. It says the report never mentions an alternative. Normally, the report says, such a witness report should weigh the possibility of the other end. And they should say, okay, maybe we are wrong. Maybe some other people who had nothing to do with Gülen movement also used this program. And they should refute that claim. They should, put it there and refute it there if they were able to. They do not even care to put that claim. So FOXIT says, in the absence of the alternative, scenario, the scenario of the MIT becomes a kind of prejudiced result. It says that actually this in witness reports is called tunnel view. You enter into a tunnel, you see only one light, you don't look back, you don't look right and left. In fact, it says the totality of MIT report was written to reach to the one and only one conclusion. And the conclusion is this, as the MIT report several times underlines. ByLock was prepared only and only for the use of the Gülenist people, and it was used only by them. This means all users of ByLock are Gülenists, and all Gülenists are ByLock users. It says it in fact gives us a lot of logical syllogism games. If anybody interested in logics, the FOXIT report is a funny reading also, because it says, the logic is like this. Every Gülenist uses ByLock, then everybody who uses a ByLock is a Gülenist. And he says, well, this is very similar of saying all fish swim. Everything that swims is a fish. Okay, so this is as acceptable as this syllogism reduction. So it criticized that one. One issue the MIT report that mentions is automatic deletion of messages. Okay, MIT said that the fact that the ByLock was actually automatically deleting the messages after some time underlines its secretive and illegal intention. Yeah. The report here says, FOXIT says, well, this is precisely what Snapchat does. This is precisely what Telegram does. Actually, this is the new world. People do not want their histories being kept in the digital realm. They want them to be cleaned, So there is nothing, suspicious in the fact that ByLock coders of the ByLock wanted the messages to be deleted after some time. This one is also refuted. The report continues on dealing with the SSL issue that we already mentioned in Moore's report, and gives extra information about use of self-signed SSL issue. It seems that this MIT's SSL understanding of why people use self-signed SSL certifications was altogether flawed. And in this case also it says it rather means that the writers or authors of MIT report was actually trying to mislead the courthouse. This, of course, underlines one fact. Use of this MIT report as if it is credible evidence by a courthouse is not only unacceptable, it is illegal. The court
and charging people on the basis of this report is also a problematic issue.
Problematic, particularly after the publication of these two reports. The Turkish courthouses has to think of using the MIT report. The overall report underlines.
Okay. Thank you very much. It was a very, very useful conversation, and it's too much to digest on here. And we'll continue our regular conversations. Kerim Balci, senior exiled journalist. By the way, good luck with your court case coming up on 18th of September. Although you won't be represented in there by a lawyer as well, with certain difficulties. We still wish things get better for you and for all other journalists who are in prison or away from country.
Thank you, Sezgin. We have to underline one issue. I was not using ByLock, by the way, so even the claim that all Gülenists used ByLock is a flawed claim. But the ByLock is used in a rather intriguing, I can say, masquerading way in the case of Kadri Gürsel, for example. He never used ByLock.
Yes.
He was called by several people who used ByLock.
Yeah.
Okay? And the courthouse even accepts this as an evidence of being the member of what they called FETÖ. So the two reports that we have read is only showing the tip of the iceberg. The problem is much, much bigger. You don't need to use ByLock. The FOXIT deals with one particular issue that you already mentioned. Maybe somebody used your Wi-Fi, and they downloaded ByLock. You never know what is ByLock.
Because the IP number would be there. But the problem is, it looks like like when you compare the numbers of 600,000 people downloaded ByLock globally, it was free on the market for up to a certain time. And then MIT suggesting that they have all the information and 165,000 people are Gülenists, and contradicting with their own view of that all ByLock users are Gülenists. We can't assume that the rest 3/4 are abroad and non-Gülenists or whatever. It's just become almost legitimizing the way they want to arrest some people. So they arrest them on ByLock. Whether they use the smartphone in their life doesn't matter, because they are registered somehow in the intelligence reports as Gülenists. So that becomes a cover-up. And if that is not long enough, then they say, well, somebody from ByLock user has rang you twice or three times, which can make it more problematic. But then we as a prominent person, as a senior journalist who were writing in Zaman, who was clear affiliation with the Gülen movement, like yourself, clearly saying not use the ByLock at all, makes it even more problematic. But that's, I think, the whole idea of that smoke screen allows the regime to do anything, to arrest anyone, including the Amnesty Turkey branch, both Taner Kılıç and İdil Eser. But that's the reason why we wanted to talk and clarify this issue.
Mr. Sezgin, let us finish with a call to the people who are arrested in Turkey on claims of ByLock downloading or using. Here we have a good example of a defender, of a lawyer, appealing to FOXIT and asking for a witness report. This is only one case, okay? Out of 75,000 cases, we don't know how many of them are linked to use of ByLock or download of ByLock. But in any case, if you are detained or arrested on claim that you downloaded or used ByLock, or on claim that your friends or your members of your family used ByLock, ask your lawyer, if you have any, to go to an international witness, expert witness, and ask for what we call in Turkish bilirkişi raporu, ask for expert witness like this one, and it has to grow as a pressure on the Turkish legal system.
And I think this itself is an opinion as well, although it may relate to a specific case like Mr. X, but in a way there is a lot of general assertions about how the intelligence report has been created and how it has been used and what the real nature of the ByLock was. So in that case, it was a very useful report and the conversation. It was a pleasure to talk to you. Thank you very much for joining me.
Thank you. Thank you.